Okay, reading Remedies, Liquidated Damages within the Damages Chapter 10, particularly the part about contract damages. Section coverage. Contracting parties may stipulate a specified sum of money which would be payable as damages to the non-breaching party for a material breach of contract. Contracting parties may stipulate a specified sum of money which would be payable as damages to the non-breaching party for a material breach of the contract. Liquidated damages serve to remove the uncertainties and difficulties involved in proving actual damages in the event of a breach, and they thereby function to reduce litigation expenses and expedite the trial process. The principal freedom of contract is not an absolute concept. It is limited by the refusal of courts to enforce extortionate or unconscionable bargains. Therefore, a liquidated damages provision is valid only if it corresponds with general notions of damages as a substitutionary measure for performance in the event of breach. If the court perceives the purpose of the clause as an attempt threat of onerous damages, the provisions will be considered a penalty and thus unenforceable. Labels applied by the parties to describe the provision as a penalty or an enforceable liquidated damages clause are not controlling. The law of liquidated damages is consistent with the common law policy of allowing efficient contract breach. This substantive policy is that a contracting party should be permitted to pay compensatory damages for a breach in exchange for the opportunity to shift goods or services to a different source in order to maximize economic resources. To the extent that a contractual damage provision operates to punish a contract breach, the goal of maximizing resources is undermined. Conversely, a liquidated damages provision that specifies a reasonable estimate of actual damages upon breach is consistent with that goal. The traditional test to evaluate the validity of a liquidated damages provision is either at the time the parties enter the contract, 1, damages resulting from a breach would be difficult to determine, and 2, the stipulated amount had a reasonable relationship to the potential damages if a breach occurred. The two criteria are not necessarily inconsistent or contradictory because the reasonableness of the liquidated sum is determined in light of the anticipated harm rather than in hindsight looking at the amount of actual damages. Thus, courts do not require precise estimates. The amount of actual damages will almost certainly vary from the stipulated in the contract. The very uncertainty in predicting future harm militates against requiring a precise matching of actual to liquidated damages. The Uniform Commercial Code 2-7181 and the Restatement Second of Contracts Section 356.1 carry forward the common law approach in a slightly modified fashion by providing that reasonableness of a liquidated damages clause may be shown based upon either the anticipated or actual harm from the breach. Section 2-718 further provides an insight into the meaning of reasonableness. By considering the difficulties of proof of loss, inconvenience, or infeasibility of otherwise determining an adequate remedy. Under both the UCC and the common law, whether the parties made a good faith pre-estimate of damages should be objectively evaluated rather than inquiring into the subjective intentions of the parties. Finally, courts may consider whether the parties intended the liquidated damages provisions to serve as an exclusive or an alternative remedy in the event of a breach. Unless the contract expressly provides otherwise, courts generally will construe the contract to allow the non-breaching party to pursue other available remedies, such as specific performance. If in that regard, however, the party seeking specific performance still must demonstrate the requisite elements for entitlement to equitable relief, including that damages were not an adequate remedy, despite the existence of the liquidated damage clause. And I skip the model case and go into Boyle versus Petrie Stores Corporation from 1985. Justice Greensfield gave the opinion. This is an action for wrongful discharge, but unlike many such cases which have besieged the courts of late, this one involves an executive employee who in fact had a carefully worked out written contract and now claiming a breach insists on a literal application of that contract. Under the contract, Boyle was to become president and chief executive officer of the corporation as of November 1, 1982. The board approved the agreement, which was duly executed and amended the corporate bylaws to reflect the fact that Milton Petrie, the chairman of the board, was to preside at directors' meetings, but that he was no longer to be the chief executive officer. Boyle, as CEO and president, was subject to the control of the board to have general supervision over the business of the corporation. Boyle, in fact, reported for work at the corporate headquarters in Secaucus, Jersey, I believe, November 8, 1982, while Boyle informed the other Petrie executives that he was now the CEO and they should take their directions from him. Petrie continued to give operating directions just as he always had. On January 6th, the formal real estate meeting and review with Petrie president was held. As various items were taken up, Petrie said, "Leave it to me, I'll take care of it." When Boyle pressed him for details, Petrie reported, "I'll take care of it." At the conclusion of the meeting, Petrie confronted Boyle in his office. With mounting anger, he said, "Where the hell do you get off to question my authority on these leases and embarrass me in front of all my organization?" He told Boyle he was moving in too fast. Boyle challenged him and impertinently replied, if you didn't have 63% of the stock, I would take you to the board of directors and have you removed as chairman. This was too much for Petrie. He exploded. You're fired. A special meeting of the board of directors was held on January 13th of 1983. The board did not discuss the terms of Boyle's employment agreement or ask to hear Mr. Boyle, but acceded to Mr. Petrie's demand that he be terminated effective immediately. Mr. Petrie retook the titles of CEO and president. A press release announced these changes and stated that the reason for the change was due to policy differences on the way business should be run. Boyle had served but 2 months of his 5-year contract. Claiming that the contract had been improperly breached by Petrie Stores Corporation, he brought this action seeking recovery of over $2 million as liquidated damages. So it's a wrongful discharge case. We just resuscitate facts, and we know he's asking for $2 million. The employment agreement is quite specific about the damages which are payable for termination other than for a material breach or just cause. Section 7A of the agreement provides that in the event of a termination other than for material breach or just cause, the corporation is to pay in one lump sum the amounts otherwise payable to employee, discounted to present value at a rate of 15% per annum. So that sounds like a material fact of the liquidated damages clause. Calculation of the lump sum payable thus works out to $1,439,352.44 in lieu of lost salary and $166,689.39 in guaranteed bonus claims for a total of $1,606,041.83. While this very substantial figure to pay a man who was on the job for 8 weeks and was fired within days after his orientation period when he tried to take over the reins of management, we are dealing here with the provision for liquidated damage designed to provide some precision for the calculation of otherwise speculative damages. Parties may properly agree to a dollar figure representing the injuries they agree the plaintiff would sustain if the contract were breached, so long as the liquidated damages provisions are neither unconscionable nor contrary to public policy, they will be enforced as written by court citations. So long as they are not unconscionable or contrary to public policy, they're usually enforced. I think that, I would say, is the principle. Defendant contends that the contractual provisions for liquidated damages are, in fact, a penalty. Stipulated contractual damages will be considered a penalty only if the amount provided for is clearly disproportionate to the actual cost and as an interim effort to assure performance regardless of economic loss. Those cases urged by the defendant as standing for the proposition that stipulated damages, such as those here involved, should be considered a penalty are readily distinguishable. Since courts have traditionally, from the time of the Merchant of Venice, viewed a forfeiture out of all proportion to the breach of contract as an unenforceable penalty, our courts have attempted to strike out the clear penalties while upholding agreement which clarified amounts of damage which could otherwise be in dispute. In this case, a termination of Boyle's employment contract could result in damages well over $500,000 a year, and the parties could reasonably agree that instead of litigating the question of damages after the event, which would leave uncertainties such as the employee's efforts to mitigate damages by securing other employment and the question as to how long other employment might last and whether the benefits were comparable, they could reasonably agree beforehand as to what damages would be payable. The amounts fixed do not exceed the total compensation provided in the 5-year contract. Both parties to the contract were sophisticated and represented by able counsel. This is a factor to be taken into consideration in determining whether one side is now exacting an unconscionable penalty. It is to be recalled that Boyle was aware of Mr. Petrie's mercurial reputation and wanted some concrete assurances of security before giving up the well-paid position he had worked himself up to with Federated Stores. An involuntary discharge from Petrie Stores would cast a considerable shadow on Mr. Boyle's reputation as a young achieving executive and possibly diminish his prospects for the future. The agreement was carefully negotiated at arm's length by reputable attorneys for both parties, and it was clearly understood that a precipitate firing of Mr. Boyle could result in very substantial contractual damages. The fact that the parties agreed to limit liability to $2.1 million, including stock options, demonstrates a realization that without such a ceiling, the actual damages could go even higher. Okay, so the lump sum payment provision here clearly was a liquidated damages provision and not a penalty. In the bargaining, neither party, so they're holding, had the ability to overreach the other. The sum provided for was not disproportionate to the damages which could be incurred. The damage provisions are valid and enforceable pursuant to their terms. The fact that that subsequent to his termination, Boyle took a position with another corporation, General Mills, as one of 6 executive vice presidents rather than as chief executive officer, does not serve to mitigate the liquidated damages. Once the parties have provided for valid liquidated damages, the sum payable becomes fixed, and there was no further inquiry to be made as to possible mitigation by subsequent employer. Okay, so this is mitigation of damages, but it doesn't mitigate damages. Here, a formula was set forth to calculate damages without regard to subsequent extrinsic facts. At the time, the parties could not know how long plaintiff would be employed if terminated. We still do not know how long the subsequent employment will continue, or whether it will give the same net to Mr. Boyle as his Petrie Stores contract over a 5-year span, since his subsequent General Mills contract is terminable at will. We need not wait to the conclusion of the 5-year contract period to find out what Boyle's aggregate loss of earnings might be, because this agreement requires liquidated damages to be paid forthwith. That clearly contemplates the damages were to be fixed as of the date of termination, regardless of the events thereafter. So that kind of explains why they're not a mitigation of damages, because the liquidation clause is supposed to be damages. I don't know if exclusive or not wasn't called into question, but nonetheless. I'm going to read the case notes. Compare the principal case with Vanderbilt University versus DiNardo. where the university sought to enforce a liquidated damages clause for an alleged breach of employment agreement by its head football coach triggered by resigning his position and taking a job at another school. The clause provided that the coach would be obligated to pay the school an amount equal to the number of years remaining on the contract multiplied times the annual salary. The court found this clause enforceable. They enforced the clause, reasoning that the university's interest in maintaining a stable football program, coupled with the difficulty of estimating the potential losses in revenues associated with ticket sales, alumni relations, and public support, satisfied the test of reasonableness. All right, enforceable and reasonable. The court further noted that the clause was the product of bargaining and operated in a reciprocal fashion, whereby the university would have liability for a breach of the agreement on an equal basis as the coach. A strong breach dissenting opinion objected that the clause was simply a disguised penalty functioning to deter the coach from taking a position at another school. The dissent observed that the use of a take-home pay measuring stick suggests that the function of the stick was to wrap the coach's knuckles and not to measure the university's loss. So what if it is a penalty? Is it less enforceable? We didn't go into that. Similarly, in Fleming versus Kent State, Ohio, 2014, an assistant football coach sought to enforce a liquidated damages clause against the university when the university reassigned him from coaching duties to a position as an assistant athletic coordinator. An Ohio appellate court found the clause enforceable. The court noted that the contract contained incentive clauses that awarded the coach bonuses if the term met certain academic and athletic goals. The court reasoned that at the time of contracting, the parties would not be able to predict whether the team would meet the goals and thus whether the coach would be entitled to the bonuses. The court also noted that the contract contained a clause regarding NCAA rules relating to athletic-related income from outside sources. The court reasoned that this clause demonstrated that the university was aware that a coach might have collateral business opportunities such as television appearances and product endorsements. Even though the coach did not have any such opportunities at the time of the breach, the court reasoned that damages arising from loss of these opportunities would have been difficult to ascertain at the time of contracting. What does that mean? It's enforceable, they said? The clause was enforceable. Okay. So the university paid Fleming. The law of liquidated damages reflects a tension between conflicting goals. It is socially desirable for the parties to fix damages in the event of breach when the amount bears a reasonable proportion to the probable loss and the actual loss is difficult to estimate with precision. Such a provision, however, should not have the effect of deterring breach through compulsion because of the potential high economic loss. See Leasing Service Corp vs. Justice, 1982. Liquidated damages may serve useful purpose but cannot have an interim effect and the promisee may reap a windfall well in excess of just compensation. Why can they not have an interim effect? In such cases, the court just going to revise it or apply another standard? It says here, effect and the promisee may reap a windfall well in excess, a windfall well in excess of just compensation. Stupid. Third, a threshold requirement for enforceability of a liquidated damages clause is that the terms must be expressly stated in the contract. See ABI versus City of Los Angeles, 1984. Cities claim to retain a developer's fee as liquidated damages not allowed because the contract did not effectively express such designation. See also Polish American Machinery Corp versus RD&D Corp. Also, in 1985, also liquidated damages will not be awarded absent material breach of the contract. So the breach has to be material. not this one. Cities claim to retain a developer's fee as liquidated damages, not allowed because the contract did not effectively express such a designation. And lastly, Woodbridge Place Apartments versus Washington Square Capital, liquidated damages in 1992, liquidated damages provisions in loan commitment agreement, unenforceable where borrower did not breach contracts but rather failed to satisfy conditions precedent to funding of loan. Right, so makes sense. These are just mistakes in liquidation damage, applying liquidation damage. So whether a contractual provision is characterized as a valid liquidated damages clause or a penalty does not depend upon the label given by the parties. See American Multi-Cinema Inc. versus South Roads. In Kansas 2000, parties' own characterization of clause as liquidated damage is or as a penalty does not control. A handful of courts, though, will give some weight to the terminology chosen by the parties as a factor in interpreting a provision fixing damages. Thus, Gator Apple LLC versus Apple Texas Restaurants, 2014, the court recognized that in reviewing the reasonableness of a liquidated damage clause, the court must look behind the words used by the contracting parties and examine the facts and the nature of the transaction. The court also acknowledged that the use of the term liquidated damages or penalty was entitled to evidentiary weight and would be controlling unless the facts and circumstances compelled a different conclusion. Thus, the court upheld the clause which the parties had termed liquidated damages because the breaching party failed to present evidence demonstrating the unreasonableness of the clause. So they need to show it's unreasonable. Breaching party failed to present evidence. It's unreasonable. Some courts have considered the intentions of the parties as a criterion for enforcement in addition to traditional two-pronged tests of reasonableness and difficulty in estimating damages. So that's like a three-pronged test. The prevailing view rejects the intention element as being surplusage. See Wilmington Housing Authority versus Pan Builders, Inc. in 1987. The intention criterion adds nothing because it validates a provision only if the other two criteria are met and invalidates a provision only when they are not. So another quoted case, Konings versus Joseph Schultz Brewing Company, 1985. Courts should consider the circumstances which give rise to the formation of the contract rather than the intent of the parties. See also Restatement Second of Contract, Section 356, comment C, Williston Contracts, etc. 1961 Corbin Contracts, 1964, blah, blah, blah. Nothing substantively added there besides just the references. Why was Boyle's subsequent employment irrelevant? Consider also Mussman versus Modern Deb Inc., where the plaintiff sued for wrongful termination of a 5-year employment contract, provided that he would receive full compensation and bonuses to the end of the 5-year term if he was terminated without cause. The trial court reduced the amount of liquidated damages by the amount plaintiff earned from other employment. This deduction was reversed on appeal, and the court restored the full amount of liquidated damages without deduction. Why should a liquidated damages clause remove the ordinary rule requiring an employee to mitigate damages? Yeah, that's confusing. So skipping case that I might as well just name as I page through it. 2 cases, actually. The case I'm skipping is Truck Rent a Center, Inc. versus Puritan Farms, Second, Inc. There's notes. There's Lake River Corporation versus Corba Bundrum Co. And notes. before we get into the land sales contracts. So I'm just going to read those notes. We'll hold off on the last case until we get to the land sale contracts. The traditional common law test for upholding a liquidated damages clause is that potential damages might accrue as a result of breach must be uncertain and difficult to ascertain. What should difficulty mean? Difficulty in forecasting all possible damages that may be caused by breach, difficulty in producing proof of damages, difficulty in proving causally the link between the breach and the loss, difficulty of meeting the foreseeability limitations for contract damages, difficulty from lack of any standardized measure of the damages for a certain breach. And they give you a case 1999. Inherent difficulty in affixing actual damages resulting from a potential breach is a factor favoring the use of the liquidated damage clause. Okay, so that's why one of the factors is uncertainty of what losses you'll experience, because they, I guess that makes it more enforceable. And that's from PYCA Industries in Harrison County. See an excellent analysis in McNeil Power of Contract and Agreed Remedies from 1962. Note 2. Although courts have intended to apply sparingly the rule that potential damages must be uncertain to enforce liquidated damage clauses, the rule is determined in some cases. A case illustrating the force of the rule is Samico Inc. versus Pipefitters Local, number 195, Texas, 1976. So this uncertainty prong under further examination. A clause in the collective bargaining agreement provided that if the employer failed to make certain specified union contributions, the employer would be required to pay 15% of the contribution total for each month the payments were delinquent. The court held that the provision was invalid as a penalty because damages for the non-payment of money could easily be calculated and therefore presented no difficulty in estimation at the time of contracting. Also see Checkers 8 Inc. Limited Partnership versus Hawkins, 7th Circuit, 2001. Absent exceptional circumstances, liquidated damages clause was invalid where actual damages caused the monetary payments being late are not difficult to measure because interest rates can be used to estimate the time value of money. So I'm guessing the uncertainty prong is important because actual damages should be paid wherever ascertainable. Why should it matter if the damages in the event of breach are difficult to ascertain? Even if the damages are exactly and readily foreseen, why not let the parties agree to that amount in advance? Is there any difference between such a liquidated damage provision and a settlement before trial? See McCormick Damages, Section 148 at 605 from 1935. California has codified the uncertainty element regarding liquidated damages by statute, which provides in pertinent part a provision in contract liquidating damages for the breach of a contract is void except where the parties to such a contract may agree therein upon an amount which shall be presumed to be the amount of damage sustained by a breach thereof, when from the nature of the case it would be impracticable or extremely difficult to fix the actual damage. California Civil Code, Section 1671D, an example of the operation of the California rule may be found in Cook v. King Manor and Convalescent Hospital, 1974. The seller sought to recover a stipulated amount of $25,000 for a buyer's breach of a contract to purchase certain real property for approximately $2 million. The liquidated damages provision recited that it would be extremely difficult and impracticable to determine the amount and the extent of the detriment to the seller if the buyer failed to perform its obligations. The court held that the provisions constituted a penalty because the seller had failed to plead and prove that the potential damages contemplated by the parties in the event of the breach were in fact difficult to estimate. See generally sweet liquidated damages in California 60, California Law Review 84, 1974. The restatement of contracts, section 356, comment B, approaches the uncertainty of loss factor with a flexible test. The greater the difficulty either of proving that loss has occurred or of establishing its amount with the requisite certainty, see section 351, the easier it is to show that the amount fixed is reasonable. To the extent there is uncertainty as to the harm, the estimate of the court or jury may not accord with the principle of compensation any more than does the advance estimate of the parties. A determination whether the amount fixed is the penalty turns on a combination of these two factors. If the difficulty of proof of loss is slight, less latitude is allowed in that approximation. If, to take an extreme case, it is clear that no loss at all has occurred, a provision fixing a substantial sum as damages is unenforceable. So uncertainty or proving that a loss has occurred. I think those are the two factors they're talking about on second read. The Uniform Commercial Code test in section 2-7181 has reduced difficulty of loss from being treated as a separate factor to serving as one consideration regarding the reasonableness of the clause. Damages for breach by either party may be liquidated in agreement, but only at an amount which is reasonable in the light of the anticipated or actual harm caused by the breach. The difficulties of proof of loss and inconvenience or non-feasibility of otherwise obtaining an adequate remedy. The UCC approach has been described by one pair of commenters as a continuum. The latitude of the contracting parties in setting damages for breach increases with the degree of uncertainty facing them. Goetz and Scott, Liquidated Damages, Penalties, and the Just Compensation Principle, some notes on the enforcement model and theory of efficient breach, 1977. Valid liquidated damage provision must reflect a reasonable estimate of the uncertain damages in the event of breach. In South Pace Properties, Inc. versus Acquisitions Group, the 11th Circuit, 1993, the court held that a stipulated damages clause in a real estate listing agreement, which provided that the broker was entitled to full 6% commission plus costs and expenses if the property owner breached the agreement, was void under Alabama law as a penalty. The court found that the damages provision was not a reasonable pre-breach estimate of the probable loss because the broker would actually recover more if the contract were breached than if fully performed. See also Ashcraft and Gerald versus Coedy, DC Circuit, 2001, liquidated damages clause in employment contract between attorney and law firm was not unreasonable where damages amount was adjusted annually with increasing increments reflecting the lawyer's greater responsibilities and value of the firm. Attell Financial Corp versus Quaker Coal Company in 2001, formula requiring a defaulting lessee to pay the present value of all monies due for balance of lease term plus anticipated residual value of equipment unreasonably disproportionate to loss and constituted a penalty. AV Consultants, Inc. versus Barnes and 1982 liquidated damages clause unenforceable as a penalty where provision would give party expected profit plus the value of its services. So the real estate one is so two of these are kind of more than you deserve. I'm not going to term it anything else than that. Note 7. What if the stipulated amount of damages from breach of a contract is considered an unreasonably low estimate of the anticipated harm? Some courts focus on the time of contracting to assess the reasonableness of the agreed amount and the uncertainty of the damages, because that approach is consistent with the traditional test for liquidated damages. So that's your analysis. Unreasonably low stipulated damages for breach of contract may reflect overreaching by favored party. The defense of overreaching requires an inquiry into unconscionability rather than the examination of unreasonableness that is necessary to invalidate a liquidated damages clause. Distinguish a contractual provision that limits damages from a provision for liquidated damages. For example, in Therolson v. 5 Genetics, Inc., 1984, the buyer's damages for the seller's breach of warranty was limited to the sale price of seed under a limitation of damages provision in the contract of sale. The court relied upon UCC 2-7193, which provides in part consequential damages may be limited or excluded unless the limitation or exclusion is unconscionable. The court noted that liquidated damages provisions usually threaten unjustifiably large recoveries such that the judicial role is to contain them with a test of reasonableness. There is an opposite concern with limitation of damages provision. The danger is unjustifiably small recoveries. The official comments of the UCC section 2-718 indicate that where the concern is unreasonably small recoveries, the proper test is unconscionability. Really. So skipping the next case, Lake River Court versus Carborundum in 1985. Looks like Kansas, since that's the law they're citing. Here's the notes. There's 7. The principal focus in determining the validity of a liquidated damages clause is the reasonableness of the relationship that the stipulated damages bear to the potential harm which the parties contemplate may accrue as a result of the breach. Another question concerns the principal focus in determining the validity of liquidated damages is the reasonableness of the relationship the stipulated damages bear to the potential harm which the parties contemplate. Right, of course, because liquidated damages is like what, a catch-all, or could be specific, or could enumerate certain damages. So the damages actually experienced should mirror that more for the liquidated damages clause to be enforceable. Another question concerns what relevance of the provable actual damages have when measured against the liquidated amount. The Restatement Second of Contracts, Section 356 in Uniform Commercial Code, Section 2-7181, both provide that reasonableness of the liquidated damages clause may be shown either by its proportionality to the anticipated or actual harm. Thus, the amount fixed may be considered valid if it approximates either alternative. See Reliance Insurance versus Utah Department of Transportation. Whether an amount constitutes a reasonable forecast is determined by reference to the time of contract formation, not the date of breach. 2. Exclusivity of remedy. Courts differ with respect to whether a liquidated damages clause serves as the exclusive remedy for contract breach. Compare Entergy Services, Inc. versus Union Pacific Railway Company in 1999. Liquidated damages clause does not preclude other remedies available in law or equity absent a clear expression of the parties to the contrary. With MCA Television Ltd. and Reverse Public Interest Corp. 11th Circuit 1999, stipulated damages provision that allows the non-breaching party a choice of options in the event of a breach is generally recognized as a penalty. Clearly, double recovery of the liquidated amount and compensatory damages is precluded by ordinary principles of contract damages, but the preclusion of specific performance is more problematic. The liquidated damages provision functions as a surrogate for the actual damages. Therefore, the liquidated damages becomes the focus of the consideration of the adequacy of the remedy at law. Recall the discussion of these issues in chapters 3 and 4. I don't understand how having a choice rather than one choice is suddenly makes it a penalty. And yeah, double recovery. Okay, no, you can't do that. So anyway, note 3, burden. The prevailing view is that the party challenging the enforceability of a liquidated damages clause has the burden of proving that it is a penalty. See Honeydew Associates, Inc. versus M&K Food Corp. First Circuit, 2001. Party who stands to benefit from determination that clauses an unenforceable penalty bears burden of proof similar to burden of raising and proving defense when challenging contract enforcement on basis of illegality or public policy. See also Melvin Aaron Eisenberg, The Limits of Cognition and the Limits of Contract, 1995. What if the liquidated sum is characterized as a reasonable approximation of the contemplated loss but the proof of actual harm is significantly less? Most courts have held that the liquidated amount must satisfy one of the alternative tests, not both. Accordingly, evidence of the actual losses resulting from the breach would be considered irrelevant, assuming damages could reasonably be anticipated at the time of contracting. And you see they're citing Carruthers Construction Co. versus City of South Hutchinson, which is another Kansas case, 2009. In Carruthers, the Kansas Supreme Court refused to apply the two-hurdle approach advocated by the defendant. Such an approach would have required the court to consider whether the liquidated sum was reasonable in light of anticipated losses at the time of contracting and whether the liquidated sum was reasonable in light of actual losses. In rejecting what it termed a retrospective approach, the court explained to impose a two-hurdle test advocated by Carruthers would deny the parties the obvious intent and deny the plaintiff the benefit of its bargain. If the amount of actual damages is made an issue in every contract with a liquidated damages provision, the very purpose of the agreement is undermined. As noted in Restatement 2nd of Contracts, Section 356, Common A, the enforcement of such provisions for liquidated damages saves the time of the courts, the juries, the parties, the witnesses, and reduces the expense of litigation. Yeah, that's what I would think the purpose is. Not to be questioned under microscope by the parties later in court. Certainly, courts to some extent may be influenced by public interest considerations to give particular deference to the validity of liquidated damages provisions in government contracts. Thus, in Carruthers Construction Company Supra, the court stated, we would supplement these points only by emphasizing that we are dealing with a contract for the construction of public utility service facilities. It is uniquely difficult to calculate damages to the general public interest caused by a contractor's breach of its agreement to provide public improvements. This should be an important consideration in such cases and weigh favorably in finding a liquidated damages provision to be reasonable. Note 6, the validation of the liquidated damages clause is reasonably proportionate to the anticipated harm, but significantly disproportionate to the provable actual losses is not limited to the context of government contracts. For instance, in Robbins v. Finlay, Utah, 1982, the court held the employer was entitled to recover $5,000 as liquidated damages for an employee's breach of covenant not to misuse customer leads, even though the employer had not introduced any evidence of actual losses incurred and had shown only that 5 potential customers were involved. In contrast, some courts have held that evidence of little or no actual losses may invalidate a liquidated damages clause as a penalty, even if the stipulated amount was otherwise reasonably related to the anticipated harm. For example, in Gorco Construction Co. v. Stein, Minnesota, 1959, the court determined that a contract provision which designated damages in the amount of 15% of the total contract price to cover expenses for advertising, labor, equipment, and commissions was invalid where the plaintiff did not prove any actual loss because of the breach. Similarly, in SOG Stan or Gardner versus Missouri Pacific Railroad in 1881, Eighth Circuit, the court invalidated a clause which stipulated $600 per day liquidated damages to cover estimated losses from delayed performance where the party asserting the claim sustained no actual damages from the breach. So it's this opposite outcome. And the last note before land sales contracts is the liquidated damages clause, which provides for payment of the sum to a non-breaching party in the event of a breach of covenants that have varied degrees of importance, typically has been invalidated as an unreasonable forecast of the anticipated harm. McCormick damages, section 151, Corbin contract, section 1066. Thus, a liquidated damages clause which fixes a payment of $200 per day for a late delivery of and shipment of good may be justifiable as an appropriate compensation for the contemplated disruption in purchaser's business operations. However, the $200 figure may be considered invalid as a penalty if sought by a seller for a breach of covenant requiring certain insurance for the goods. In Co. vs. Thermosol Ltd., though, the court upheld, this is North Carolina, I think, maybe 1985, though the court upheld the enforceability of liquidated damages clause, even though it could be triggered by a breach of several covenants because the covenants were interdependent and call for acts with one primary purpose.